4. What records must I keep and for how long?
Records retention is a critical part of the hiring, and for that matter, termination, process. The paper record that you create and save as an employer will help you avoid legal liability or at least reduce its risk. Federal as well as state law governs retention of information gathered or evaluated in the employee selection or termination process. Sometimes these laws stipulate conflicting requirements. As a result, you should use caution when discarding any routine or no routine records that will help you substantiate any employment-related decision that could later be challenged. Tell me more. The following laws stipulate different, and sometimes conflicting, record retention requirements. Title VII of the 1964 Civil Rights Act. Fair Labor Standards Act, FLSA. Age Discrimination in Employment Act of 1967, ADIA. Americans with Disabilities Act, ADA. Immigration Reform and Control Act of 1986, IRCA. Unemployment Insurance Codes. Employee Retirement Income Security Act of 1974, ERISA. Consolidated Omnibus Budget Reconciliation Act of 1985, COBRA. For the sake of simplicity, we'll choose the longest time retention requirement period that these sometimes conflicting laws stipulate. For example, Title VII requires that employers retain payroll records for 1 year, FLSA requires 3 years, the Unemployment Insurance Code requires 4 years. Therefore, the table presented here stipulates that 4 years is the appropriate minimum time period to retain these records. Be aware, however, that certain records, such as pension plan documents, should be retained permanently. Speak with qualified counsel regarding your specific questions and about your state's particular requirements.